Due Process, recipient of 5 Mid-Atlantic Emmy Awards since 1997.
It's all been burglary, robbery.
That's it.
No violence.
No violence.
No assault.
No assault. Never.
But Kevin Paulk is in for life, at least 35 years with no parole, the result of New Jersey's 3 strikes law. Is it working? Is it fair? 3 strikes and you're in on this week's edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
The repeat violent offender, the kind who may make you feel unsafe. Who wouldn't want him off the street? It's no wonder the legislature jumped at the chance to lock him up for life. I'm Raymond Brown, and now 5 years later, we look back on New Jersey's 3 strikes law. Has it done what it was designed to do? Is it constitutional? Is it even effective? We'll get both sides of that story from our guests here in the studio, but first, here's Sandy King with a look from inside Trenton State Prison.
Raymond, he's one of only a handful of New Jersey's 3 strikes lifers. The reason there are so few, we're told, because unlike California, where 40,000 people have been jailed for life, some for relatively minor crimes, New Jersey's law is narrow, triggered only by the most serious violent crimes. But when we met Kevin Paulk through glass by phone in a maximum security interview room, he didn't quite fit the profile of the vicious, violent offender.
I thought that the 3 strikes law was for heinous crimes, crimes of murder, crimes that involve serious violence, things like that.
So when did you find out that you were going to come under 3 strikes?
When I went to the courtroom, the prosecutor stood up and said that we're seeking 3 strikes for this gentleman.
And 3 strikes was what he got. A sentence that says he'll stay in this place at least until he's 70 years old. That's 35 years or more locked up.
The prosecutor, she was so overzealous. She was sashaying back and forth, like she had Hannibal the cannibal sitting there.
And she was successful. Kevin Paulk became one of the handful of New Jersey inmates to feel the brunt of the Persistent Offender Accountability Act. 3 strikes and you're in for life.
Burglary, robbery. It's all been burglary, robbery.
That's it.
No violence.
No violence.
No assault.
No assault. Never.
Paulk insists he has never been violent, and despite a long record of small-time robberies, his record confirms he has no history of causing any physical injury. But he did use toy guns in his holdups, and the law says that's all it takes to classify him as a menace to society, a violent repeat felon, toy gun or not.
What difference does it make? When someone comes up to you with a gun, how do you know whether it's a real gun or not? We've experienced that with our police department. Somebody points a gun at you, it's a gun.
So you'd say that's an appropriate sentence?
Absolutely. Absolutely. Don't commit that crime. You scare me just as much if you stick a toy gun in my back as you do as if you stick a real gun in my back.
Louis Costco was the sponsor of 3 strikes in the Senate, and he's convinced the law has done exactly what it was supposed to do.
The purpose of it was to try to stop people from committing crimes over and over again. And the proof is that it's worked. Now, the experts can't tell us why our crime rate is the lowest that it's been in the past 25 or 30 years. They won't tell us that it's because of the legislation that we've passed.
Of course, the crime rate had begun its decline years before 3 strikes became law. Gregory Oliver was the first to feel the impact.
The defendant, Gregory Oliver, shall be sentenced on the first-degree robbery conviction to the custody of the Commissioner of the Department of Corrections for a term of life imprisonment under the Three Strikes and You're In Act, it must be at least 70 years old before the defendant would be granted early release, subject to parole board determinations that the inmate does not pose a danger to the community.
Gregory, too, had a long criminal record, and like Paulk, he'd already spent much of his life behind bars.
So in this case, the defendant has not only one prior strike, he has not only 2 prior strikes, he has actually 3 prior strikes.
The legislature's intention in enacting this legislation was to protect the public from persons who persistently commit serious and violent crimes. And unlike Paulk, Oliver would have fit any definition of violent.
He left me for dead, and from the help of others, I was saved.
Leon Johnson suffered a coma, and in surgery to save his life, he literally lost a piece of his brain, robbed in a Patterson crack house by Oliver, who fractured Johnson's skull with a pipe.
He has done nothing else in his life but hurt people, victimize people, take from people, damage people physically and materially, and that simply has to come to an end.
But there was no Leon Johnson, no injured victim at Kevin Paulk's trial, and he says if he'd had more vigorous representation, he would never have been sentenced under the Three Strikes law.
He didn't do anything. He was a public defender to us is like nothing. We don't have nothing. A public defender is nothing. We don't have it's nothing. If you don't have no money, if you can't afford a decent attorney, you are through.
And unless the Three Strikes law is eventually thrown out, he is through, with a sentence that exceeds that handed down in case after case of rape or even murder.
My record says that I'm not a vicious, violent felon because I don't have any vicious, violent crimes. Don't.
You're still in here for life.
Yes, I am. There are people walking in and out of these places after killing people, after raping and sodomizing little boys and little girls. I've seen it. I mean, I'm in this place with people who have committed heinous crimes. Now, there's no way in the world that a man like me should be sitting in this place for the rest of my life for the crimes I committed. There's just no way.
And based on his claim that he was poorly represented, that his crimes were many but not major enough to warrant life, Kevin Paulk, with the help of some jailhouse lawyer friends, has filed an appeal. And the state's public defender's office has also filed appeal, but on behalf of Gregory Oliver, whom we saw in that Patterson courtroom. The claim that the three-strike law is cruel and unusual punishment is now before the state Supreme Court. And Raymond, should the appeal be successful, 3 strikes could be overturned.
Sandy, we'll hear the arguments against 3 strikes and for it when we come back. A tough-on-crime prosecutor, a leader of the state's criminal defense lawyers, and a Rutgers criminologist fight it out when we come back. So stay with us.
I think it's unfair because people could change.
How 3 strikes has affected the state of California, it's made it basically a prison state.
It depends on how serious the crimes are.
How serious are they talking about? Is it rape? Is it murder?
You know, if they just seem to have this history, you kind of got to look at the better for the society.
If they take someone's life, then I think they should just automatically be in prison for life.
If they're serious enough, then yes, I do believe they should be behind bars.
I don't think that they should be sentenced to life in prison.
I guess it depends on the crime.
If it's your 3rd felony, you go to jail for life, and that could be for stealing 3 cans of beer or something stupid like that.
Stick them in there, leave them in there, so they can't get out and hurt anybody else.
It's definitely a good idea.
I say 2 strikes and you out.
The jails are going to be pretty crowded.
The consensus in our admittedly unscientific survey that whether or not 3 strikes makes sense depends on the crime it covers. Does it make sense? Does it work? Is it legal? We can expect some very different answers from Monmouth County prosecutor and former head of the National Association of District Attorneys, John Kay, from Professor Candace McCoy of the Rutgers School of Criminal Justice, and in Newark, from Kathy Walder, former head of the New Jersey Association of Criminal Defense Lawyers. Welcome to you all. John, let me start with you. Now, I'm not going to take the position that even a guy with a red toy gun is not committing a crime. But it does seem, if we look at a life sentence for this guy, it does make one wonder about the effectiveness of a law that seems to rank him among the most serious offenders in the state by giving him life.
Actually, the statute is pretty minimal in the number of crimes that are involved that can trigger this mechanism. But anything involving a simulated weapon is a serious matter. Most of this stuff is the reaction of the legislature to what they believe to be lenient judges. They've tried to take away the discretion of judges. They've been doing it for 20, 25 years. This is the ultimate taking away of the discretion of judges, I believe.
Now, in this particular case, we're looking at a guy who everybody would concede committed crimes that should be taken seriously. On the other hand, you have a legislature which, as you point out, has said, well, look, there's a serious problem, but if there are only a handful of people in 5 years who qualify, one wonders how much the statute was needed and whether it justifies the potential misjustices of having somebody like Kevin Paulkin.
You know, that is a good issue. I looked at the numbers in Monmouth County, and we rank as one of the highest counties for the number of crimes committed. We've had only 4 people that even qualified under this act in the 4 or 5 years that it's been around.
And I can tell people personally that your office is pretty tough. So if your office has only generated 4, it suggests that maybe this is a statute that's more of a response to political rhetoric than to real need. What do you think, Professor?
Well, I'm not going to fight with anybody on this one. I'm sorry, this doesn't make good TV. But I do agree that it's unnecessary. We already have laws in New Jersey that are locking up these serious, violent criminals for a very long time. Unlike other states, such as California was mentioned, where less serious crimes count as strikes.
And they've got 40,000 incarcerated under this.
Absolutely, it's a travesty. However, Jersey was smart enough to not do that. You say, well, why then have they done something that's unnecessary?
And it's a good TV question, too.
Well, I think, first of all, it's pandering to public misconceptions about crime and criminals. You know, we're doing things, it was always something new. And as has been mentioned by Mr. Kaye, the idea was, let's control the judicial discretion. Let's get rid of the lenient judges. Well, you know, the metaphor in 3 strikes is baseball. So in baseball, there's an umpire. That umpire is going to decide whether it's a strike or not. Now, if it's not the judge, it's going to be the prosecutor, and the prosecutor is calling what is a strike and what isn't. And there's a lot of prosecutorial discretion here that could be misused. I'm not saying it is, but it could be. When you have too many laws, unnecessary laws, overlapping laws, you open up the capacity for this.
Kathy Walder, if the professor suggests we need umpires and the state Supreme Court at some point is going to take a look at this statute, what's the chance that the court is going to find a basis to attack it, or do you think we've got to look elsewhere?
Well, I think we have to look elsewhere, Raymond. The court seems to be growing in its conservatism over the past several years. I agree with both Prosecutor Kaye and the professor that our judicial discretion has now been so limited that it's almost unnecessary to qualify to be on the bench in this state. We're one of the few states that are lucky enough not to elect judges, but to appoint them through merit and through a very lengthy investigative process. Why can't we place our trust in the bench rather than add more rules because people think we need more rules?
Well, Kathy, despite your youthful appearance, you were practicing almost as long as I. Do you know all these easy judges who are letting people out all the time before the legislature began to restrict discretion?
I'd love to meet an easy judge, Raymond. It's been many years since I've been in a courtroom where a sentence has gone as I felt it should my way.
Well, John, do we have a realistic assessment of where judges are? I mean, is it necessary to so restrict discretion because there are scores or significant numbers of judges who don't seriously assess the impact of sentencing both on a defendant and on society?
I don't think we've ever had a serious problem in New Jersey of lenient judges. I think, though, that we're in a media area where they did have a problem, and the problem was generally in New York. And also, the problem was perceived to be some federal judges. Now, those federal judges are retired. We're saturated with New York media. We think that that's what happens in New Jersey, and I don't think we get the credit for what actually goes on. I want to follow up on one point, though, the professor made. As the judge's discretion has been taken away from them, that discretion has lodged more in the prosecutor. And the issue of the prosecutor abusing that discretion, insofar as 3 strikes goes, is not an issue because the proof is there's so few people that are actually serving 3 strikes in New Jersey.
But let's take a look at a case like Kevin Polk. Let's assume
the
that,
gentleman
right, the gentleman we just
yeah.
saw. Let's assume that his case is as it seems to be. A guy who was clearly in violation of the law, committed crimes, but probably not the kind of person we would think needs to be in prison for life. Does the prospect of 1 or 2 or a couple, because if you only got a handful and you got 1, it's a big number, especially to him. Right. Does that prospect undermine faith in justice, especially for that person? What would you say to Kevin?
That's probably one of the problems with mandatories to begin with. I mean, I'm not opposed to all mandatories, but some of them, you can't apply the same cookie cutter to every single situation. His crimes deserve time. I mean, there's no question. Simulated weapon or not, he deserves to be locked up. So for 35 extra years till he's 70 years old, well, that's another issue.
Would you be unhappy if the legislature repealed the 3 strikes?
I don't think, quite frankly, I don't think it would have much impact upon what we do for them. We have mandatories throughout the law. We have it for drug crimes. We have it for hate crimes. We have it for just about everything. It's a cumulative effect. Years ago, we had 2 strikes and you're in, actually. I mean, that was the old law. Now we've got 3. And we lock up for long periods of time in New Jersey.
So given the rest of the arsenal, you wouldn't be unhappy if the legislature took this piece out, given its ability to work mischief?
I really don't think it would have much impact. And the proof is there's so few people that are actually serving time under the law.
But, Professor, let me come back to your use of the term metaphor, which I always think of as, it reminds me of my 3rd grade teacher making me define metaphor, use an example from, but as a symbol, this is perhaps a statute. If you asked 100,000 people across the country who are not practicing law or involved with the system, tell us something about criminal justice, I'm sure most of them would recognize the phrase 3 strikes and think of it as a significant part of the arsenal that the state has to protect citizens from crime. And yet, as we look at least in New Jersey, it seems not just unnecessary, but maybe something that can wreak some mischief. Why are we willing to tolerate that kind of thing?
Well, we're willing to tolerate it because it makes us feel better that something is being done against these predators. In fact, something was being done and continues to be done. Jersey, once you get a rough, serious, violent, repeat violent felon, that person would not be on the streets even if we didn't have 3 strikes. Interesting, you asked, well, what would happen if we repealed it? There's a second part of the 3-strike statute. Again, back to the metaphor. If it's not a strike, maybe you'd get a base on balls under this second part of it. And that is that there's an extended term for people who are 1 notch below the really serious, violent felon. And I think our friend, I think it was Mr. Hawk. Right, thank you, should have been under that one. Now, it was up to the prosecutor to call that strike. And this is what I'm talking about, prosecutorial discretion.
Okay. And maybe also up to the defense lawyer. Kathy, let me turn to you for a moment. I know we don't know who Kevin Polk's lawyer was, and we're not talking about him specifically, but I think that one of the issues that the defense bar needs to talk about publicly is, are there instances in significant number of occasions when people are not effectively represented in criminal cases? Is that a problem we should be concerned about?
Absolutely, Raymond. I think that it's unfortunate, but young lawyers just starting out are given very difficult cases to handle. There's such a high volume in our larger counties. They don't have time to prepare them. Many clients complain they don't even see their attorney until they go to court and plea bargain. The volume is also apparent once you're in court by the push that's on to plea bargain cases. We thought, I think initially, that the 3 strikes law would result in more trials. I don't know that that's necessarily true. I think it's resulted in a lot more plea bargains, perhaps to avoid that, but the plea bargains are very, very severe.
Kathy, when you said you thought it would avoid more trials, you have to explain what you mean.
Excuse me, I thought it would bring more trials, not avoid more trials.
Bring more trials?
Yes, absolutely.
Defendant saying, look, if I'm going to risk that much, I'm going to trial and not involve myself in a plea bargain.
For all the marbles, you got nothing to lose.
And why didn't that happen?
I have no idea, Raymond. Perhaps, as Prosecutor Kay says, it hasn't been a situation where there are enough people that have been exposed to the 3 strikes. I'm not quite sure statistically what the reasons are, but I don't believe there's been an increase in trials.
You know, the reason that I bring this up in the context of this discussion is not just that Mr. Polk said that he had poor representation, but it's my view that one of the darker secrets of the justice system is ineffective assistance of counsel, because who has a motive to really raise it? Do you think that's
a very important point, and it covers the entire system and not just this one little issue of the serious violent predator. I wouldn't call it ineffective assistance. I would call it the problems of an inherently coercive system that relies so heavily on guilty pleas. That's related. The ineffective assistance is related to that question, but it gets down to the bottom line issue of people will plead guilty for a lot of reasons, including that they think they don't have any alternative.
And are you suggesting even that people who are not guilty of the offense plead guilty to those
They
reasons?
do. They know they're guilty of something, but they will end up pleading guilty to serious things that they don't quite understand. That gets into the ineffective assistance question.
Okay. Now, the reason I use the term ineffective assistance, we try to stay away from legal jargon, but the courts have used that, and essentially it means if the defense lawyer is awake, and sometimes not even that, somehow we'll figure out that it was okay whatever he did or didn't do.
That's
or she
why
did
the ineffective assistance question and is the defense attorney awake or not is not the main point here. The main point is if you are a defendant and you know that if you exercise your right to trial, it is likely to go even heavier for you if you are convicted than if you plead. You are going to do the rational thing that any of us would do and say, well, I'll go for the sure thing that is likely to be.
What's wrong with that? Why does it bother you?
It bothers me because I do believe in the right to trial.
And so you think people are being essentially punished for things that they didn't do, or which are more serious than the things they did,
or things that have not been proven. Things that have not been proven. And the three strikes thing is a very important.
What's the solution?
I think more bench trials, but that's a topic for
Kathy
another
Walden.
day.
Yeah, she's thrown it out. I got it. Kathy, a bench trial, meaning a trial before a judge. What percentage of the cases you've had would you have been willing to give up a jury and go with the judge?
Not many. I've done it, Raymond, but it was on more or less an agreement or a prearranged understanding as to the outcome, quite frankly. My appeal as a defense attorney is to a jury.
Okay. You mean a wink and a nod where you thought you knew what the judge would do?
Yes, a discussion between the prosecutor, the judge, and myself, and somebody that wanted a trial because they thought that was the way to go, rather than another disposition as a plea or a dismissal. And it's usually, you're right, a wink and a nod.
Okay. Kathy didn't surprise me with her response. John, what about you from the prosecutor's point of view? More bench trials, something you'd be happy with?
We do it sometimes. We don't find much difference in it. I do want to make one quick comment, though, if I could. The public defenders of this state work pretty hard. They're very overworked. A lot of them been around a long time, not just the young ones that Kathy mentioned, but they are talented people. It does prosecutors no good to win cases against incompetence. I mean, we want better lawyers on the defense side because then we're going to get continuous appeals. It just does us no good. Not everybody can have Kathy Walder.
But you must. Resources do make a difference. The person who's got the money to try to put up a stout defense is probably going to be in a better position than the person without resources.
But we also have the situation with prosecutors. Not everybody has the budget to train prosecutors. Law schools don't train prosecutors. I mean, we happen to spend a lot of money in Monmouth County training prosecutors.
But who's going to be in a better position to go to the legislature to ask for more money?
We are.
I think prosecutors, I suspect.
No question.
Okay. Now, I want to come back to the bench trial issue. I mean, do you think it's interesting that the defense, and I suspect that Kathy speaks for most of her colleagues, would say no bench trials, and the prosecutors would say, makes no difference to us, we can pretty much take the fact finder wherever it is. Does that tell you something about why there aren't more bench trials and why that might work a problem?
Well, it's not surprising to me that these were the comments, and these are fine professional people who are working within this system and have worked within it all their lives. They know what they're dealing with. This is how the system is set up. The question is, do we have to set the system up like that? There are alternatives. A bench trial as they used to do in Philadelphia, actually, and as they used to do in California.
Not a widely regarded legal justice system in Philadelphia, regarded as corrupt, ineffective, and not
20 years
very...
ago.
Not been, John, have you heard much different?
It's not that long ago, I wouldn't think.
I would hardly find that a model.
The point on the bench trial is that the evidence gets actually brought into a court instead of being part of a wink and a nod let's talk winks and nods. That's what the guilty plea process is. The actual evidence gets looked at, and if needed, it is challenged. In other words, the case is proven. Now, if you had to do that before a jury with all the posturing that goes on in voir dire, et cetera, and all of the mystification that goes on with jury trials, it would be too cumbersome.
Okay,
Get a
let me
good
interrupt you because
judge,
we're running
it
out of
would
time.
work.
I want to go one last question on 3 strikes. You're all in the legislature. This statute comes up. You vote yes or no? This statute, the one we have in New Jersey.
No.
John?
I'd vote yes.
You'd vote yes? Kathy?
Repeal.
Repeal. Now, we'd have to question your no vote, your yes vote, John, because you seemed like you were critical of the statute.
The reason is that the statute can be helpful. It can resolve cases. It can be a hammer to
Well,
hold over
we'll find out
someone's
if we're
head.
going to resolve this issue when we return to it some point in the future. In the meantime, we've been talking about a cutting-edge legal question, as we do each week here on Due Process. So you want to join us next time when we'll shift our focus to another issue of law and social justice. Till then, for Sandy King and all of us here, I'm Raymond Brown. Thanks for watching.
I say I believe in life for life. You take a life, you should spend your life in jail. I believe in that. But if you don't take a life, you shouldn't have to give your life. You know, and if you don't hurt nobody, you know, why should you be hurt in return? I mean, that's the way I feel.
But you're in for life.
Yes, I am. Like, just as if I was one of the most heinous criminals that walked the face of this earth. I'm under that. I'm in that same category as all the rest of them. You know, but inside, I know I'm not. You know, but I'm still here with the rest of them until hopefully I can get an attorney that can help me with this case. Other than that, there's nothing I can do but try to fight it the best I can.
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,